As I meet with clients to discuss their wills and trusts, one of the questions that always comes up is what is the difference between a simple will and a living trust? To answer that question, let's look first at simple wills. As the name implies, they're a fairly simple arrangement. They're typically short, just 3 or 4 pages long, and they really accomplish just 2 or sometimes 3 things. First of all, they're an opportunity for you to decide who is going to receive your property when you pass away. Secondly, they also are an opportunity for you to designate the person that you would like to act as your executor or your personal representative to make sure that your instructions are followed. And finally, if you have minor children, they're an opportunity for you to designate in whose home those children will be raised if you pass away. The document is fairly short, fairly straightforward. It does, however, have a couple of disadvantages. First of all, if you have minor children, using a simple will requires that upon your death, the inheritance goes to those children. So if you'd like instead for the inheritance to be held until your children get older and become more mature, a simple will is not a good option. Secondly, for everyone, whether or not you have minor children, use of a simple will requires that on your death, your estate, your family will be required to go through the probate process. That process by statute takes a minimum of 6 months to complete, and there are a number of expenses that are attached to it. In a typical estate, between the court fees, the lawyer fees, the publishing notice to creditor fees, total expenses are going to be in the $2,000 to $5,000 range. Remember though, if you are a married couple, you'll have that expense when the first spouse passes away, and you'll have the same expenses again when the second spouse passes away. But that is what a simple will is and what it accomplishes. Now, if instead you want to hold an inheritance for children until they become more mature, or if you'd like to avoid that probate process, the best option for that is the living trust. A living trust, on the other hand, is a different arrangement. The heart of a living trust is the living trust agreement, in which you will express, number one, who's to receive your property when you pass away, and who's to be responsible for making sure that your wishes are followed. But in the meantime, while you're still living, we place all of your property into the living trust. You are the trustee of that trust, meaning you run the situation. There is no one else to whom you are answerable. In addition, you're the beneficiary, so all of your property, all of your belongings to continue to be available to take care of your financial and other needs. But when you do pass away, the successor trustee that you've named will simply step up and take control of the situation to distribute the property in the manner that you've directed. There's no requirement of going to court. There's no time delay. It can happen very quickly and without any attorney or court involvement whatsoever. So there are distinct advantages to a living trust. The living trust agreement has other documents that are part of that complete package. Number one, we have a couple of short wills that essentially function as a safety net, so that if there was some asset that you owned while you were living that you forgot to put into the living trust, under the will it specifies that goes into that trust, and then from the trust it'll be distributed out to your heirs. Number two, we typically would have living wills with that, again to tell the world what sort of medical care you want in the event you're in a coma. Number three, we'll have powers of attorney, so that you've directed the world who can speak for you on medical issues and financial issues in the event that you're unable to take care of those decisions and issues on your own. The last item in the package is a deed. So we actually transfer ownership of your home from your name into the trust that you control. So that whole package is a complete living trust package. If you have my office prepare that package for you, the cost will be $1,495. Now compare that with a simple will with power of attorney and living will. The fees for that for a married couple would be $525. So for a little bit less than $1,000 more, you're able to advance from a simple will to a living trust. But the savings in the long run are substantial. Remember, the cost of probate is $2,000 to $5,000 per person. So for a married couple, for that additional expenditure, you'll be saving between $4,000 and $10,000 of total probate costs, plus the delay, that 6-month delay, is eliminated as well. That's the reason why most of my clients, once they understand the situation, do opt to proceed with a living trust. These are important decisions for you and your family. If you have additional questions, I hope you'll call my office at 208-939-2600. I'd be happy to answer your questions over the phone or to schedule a time to come in for your free initial consultation. Thank you for watching this video. I hope it's been helpful to you, and I look forward to hearing from you if I can be of further assistance. Thank you.